Good day, everyone, to my fellow law students, especially to our professor in Introduction to Law, Attorney Christine Tabing, ma'am. Again, good day to all of us. Today, I will be discussing to you regarding the executive privilege, the report assigned to me. First, let's tackle what is the definition of the executive privilege. It is the power of the President to withhold certain types of information from the courts, the Congress, and ultimately the public. So that's the definition of executive privilege. Next, the scope of the executive privilege. The scope of executive privilege are presidential conversations, correspondences, or discussion during closed-door cabinet meetings, like the internal deliberations of the Supreme Court and other collegiate courts, or executive session of either House of Congress are recognized as confidential. So this kind of information cannot be pried open by a co-equal branch of the government. So we have kinds of executive privilege. First kind is state secrets privilege. Second one, informer's privilege or the privilege of the government. Third one, the generic privilege. So the state secrets privilege as the first kind of the executive privilege. The information is of such nature that its disclosure would subvert crucial military or diplomatic objectives. And for informer's privilege or the privilege of the government, it is the non-disclosure of the identity of persons who furnish information of violations of law to officers charged with the enforcement of that law. And then the generic privilege for internal deliberations attached to intra-governmental documents reflecting advisory opinions, recommendations, and deliberations comprising part of the process by which governmental decisions and policies formulated. And let's proceed and let's discuss rather that two cited cases assigned to me, which are first the Senate versus Ermita with the GR number of 169777 dated April 20, 2006. The second case, Neri versus Senate Committee on Accountability of Public Officers and Investigations with the GR number of 1808843 dated March 25, 2008. So let's discuss first, no? Facts of the case, Senate versus Ermita. Here's now the facts. The Committee of the Senate as a whole issued invitations to various officials of the Executive Department for them to appear as resource speakers in a public hearing on the railway project. However, the President issued Executive Order 464 used by invoking rather that Executive 464 invoking executive privilege. This was used by Ermita in response to the invitation of the Congress. So the title, no, or the main content of the executive is ensuring observance of the privilege of separation of powers, adherence to the rule on executive privilege, and respect to the rights of the public officials appearing in legislative inquiries in and of legislation under the Constitution and for other purposes. So the Executive Order number 464 issued by President Gloria Macapagal Arroyo prohibits the executive senior officials from appearing in Congress without her permission. So that's the intention of GMA. And for the issue of the case, whether or not the Senate has power to inquire into the operations of the executive department. So, automatic, the decision of the Supreme Court, petition partly granted. Why? Because Congress has power to inquire into the operation of the executive branch. It would be incongruous to hold that the power of inquiry does not extend to executive officials who are the most familiar and informed by executive of operations. And now let's proceed to the case of Neri versus Senate Committee. Facts of the case. On April 21, 2007, the Department of Transportation and Communication entered into a contract with Zhongxing Telecommunication Equipment for the supply of equipment and services for the National Broadband Network or NBN project in the amount of 329,481,290 US dollars. Approximately, the equivalent to the currency of the Philippines is 16 billion pesos. The project was to be financed by the People's Republic of China. The Senate passed various resolutions relative to the NBN deal in September 18, 2007, hearing Jose de Benicia III testified that several high executive officials and power brokers were using their influence to push the approval of the NBN project by the NIDA. So here's now, Neri, the head of NIDA, was then invited to testify before the Senate Blue Ribbon because of the said report by Jose. He appeared in one hearing wherein he was interrogated for 11 hours, and during which he admitted that Abalos of Comelec tried to bribe him with 20 million pesos in exchange for his approval of the NBN project. He further narrated that he informed President Gloria Macapagal Arroyo about the bribery attempt and that she instructed him not to accept the bribe. So during the conversation of Neri, the head of NIDA, he reported to President Gloria Macapagal Arroyo about the bribe, but Gloria Macapagal Arroyo, according to the statement of Neri, prevented him not to accept the bribe. So, however, when probed further on what they discussed about the NBN project, petitioner refused to answer, invoking executive privilege. In particular, he refused to answer the questions on so here's now the question of the Congress, whether or not President Arroyo followed up the NBN project. See? Second, whether or not she directed him, that was Neri, to prioritize it. And the third one, whether or not she directed him to approve. So, he later refused to attend the other hearing, and Ermita sent a letter to the Senate averring that the communications between Gloria Macapagal Arroyo and Neri are privileged, and that the jurisprudence laid down in Senate versus Ermita be applied. He was cited in contempt of respondent committees and an order for his arrest and detention until such time that he would appear and give his testimony. See? And now the issue of the case are the communications elicited by the subject. 3 questions covered by executive privilege. So here's now the ruling of the case. The communications are covered by executive privilege. The revocation of Executive Order number 464 does not in any way diminish the concept of executive privilege. This is because this concept has constitutional underpinnings. So the claim of executive privilege is highly recognized in cases where the subject of inquiry relates to a power textually committed by the Constitution to the President, such as the area of military and foreign relations, Under our Constitution, the President is the repository of the Commander-in-Chief, appointing, pardoning, and diplomatic powers. Consistent with the doctrine of separation of powers, the information relating to these powers may enjoy greater confidentiality than others. Several jurisprudence cited provide the elements of presidential communication privilege. The first is, the protected communication must relate to a quintessential and non-delegible presidential power. Second, the communication must be authored or solicited and received by a close advisor of the President or the President himself or herself. The judicial test is that the advisor must be in operational proximity with the President. The third one, the presidential communications privilege remains a qualified privilege that may be overcome by a showing of adequate need, such that the information sought likely contains important evidence, and by the unavailability of the information elsewhere by an inappropriate investigating authority. Excuse me po. In the case of Barr, Executive Secretary Ermita premised his claim of executive privilege on the ground that the three questions fall under conversation of correspondence between the President and public officials, necessary in her executive and policy decision making process, and that the information sought to be disclosed might impair our diplomatic as well as economic relations with the People's Republic of China. Simply put, the B's are presidential communications privilege and executive privilege on matters relating to diplomacy or foreign relations. Using the above elements, those three elements of the presidential communications privilege, we are convinced that indeed the communications elicited by the three questions are covered by the presidential communications privilege. First, the communications relate to a quintessential and non-delegible power of the President. The power to enter into the executive agreement with other countries is authority of the President to enter into executive agreement without the concurrence of the legislative has traditionally been recognized in Philippines jurisprudence. Second, the communication are received by a close advisor of the President. Under the operational proximity test, petitioner can be considered a close advisor of the President, being a member of a President Arroyo's cabinet. And third, there is no adequate showing of a compelling need that would justify the limitation of the privilege and of the unavailability of the information elsewhere by an appropriate investigating authority. Respondent committees further contend that the grant of petitioner's claim of executive privilege violates the constitutional provisions on the right of the people to information on matters of public concern. We might have agreed with such contention if petition did not appear before them at all. But petitioner made himself available to them during the September 26 hearing, where he was questioned for 11 hours. Not only that, he expressly manifested his willingness to answer more questions from the senators, with the exception only of those covered by his claim of executive privilege. The right to public information, like any other right, is subject to limitation under Section 7 of Article 3 of the 1987 Philippine Constitution. It provides the right of the people to The information on matters of public concern shall be recognized. Access to officials' records and the documents and papers pertaining to official acts, transactions, or decisions, as well as the government research data used as basis for policy development, shall be afforded the citizen, subject to such limitations as may be provided by law. So that's how the executive privilege regulates during the occurrence of that cases before. Thank you so much for listening this report about the executive privilege, and hoping that you gained a lot of information and learning. Thank you and keep safe. God bless everyone.